Depending on your legal status in the US and your child's age and marital status, you have a right to bring them to the US permanently. The procedures to apply for the green card may differ. Let's learn more about how you can get a green card for them. Hi, I'm Shariq Khan and I'm the South Asian attorney. As a US citizen, you can get a green card for any unmarried children under the age of 21 or any adult children over the age of 21. In some cases, you may also apply for a green card for your children's children. As a green card holder, you may also get a green card for any unmarried children under the age of 21 or any adult children. However, if your child is married, you will not be able to apply for a green card for them as a green card holder. In this case, you may want to wait to become a US citizen first. USCIS considers the following to be your children: a biological child, a stepchild, and an adopted child. A biological child is any child conceived and therefore carrying genes from the parent. A stepchild is a child of your husband or wife by a previous marriage. You can apply for your stepchild's green card if you and your spouse were married before your stepchild turned 18. You can also apply for your adopted child as long as you adopted the child before their 16th birthday and you have lived with them for at least 2 years. The first step is to fill out Form I-130. This form is also known as a petition for alien relative. It establishes a relationship between you and your children. As soon as USCIS receives your I-130 petition, it gives your child a place in line to receive a green card. Just so you know, this place in line is called the priority date. More on this later. Once you've filled out this form completely, you'll have to submit it along with supporting documents. These documents will prove your citizenship and your relationship to your children. You can prove US citizenship by submitting a copy of your passport or a birth certificate if you were born in the US, or report of birth abroad, or a certificate of naturalization, or a certificate of citizenship. If you're a green card holder, you can prove US residency by showing a copy of the front and back of your green card. If you're the mother of your child, you can prove your relationship to your child solely by submitting their birth certificate. However, this birth certificate must contain your name. If you're the father of your child, you must also show the birth certificate with your name on it. Additionally, you'll have to show your marriage certificate. If you're no longer married to the mother of your child, you should provide proof of legal termination of your marriage. If you are not married to the mother at the time of the child's birth, you must submit a marriage certificate showing your marriage to the child's mother before the child turned 18. If you never got married to the child's mother, then you must provide proof of financial and emotional relationship with your child. If you are a step-parent, you'll have to provide a copy of your child's birth certificate, copy of the marriage certificate to the child's biological parent, proof of legal termination of you and your spouse's previous marriages. If you're an adoptive parent, you must show a copy of your child's birth certificate, a copy of adoption record, and proof of 2 years of legal and physical custody of the child. If you're finding this video helpful so far, I'd love it if you could like and subscribe. It helps my practice grow. How long will it take for your children to get a green card? To answer that question, let's determine their category first. USCIS considers children of US citizens who are unmarried and under 21 immediate relatives. The good thing about being an immediate relative is that they have no quota restrictions, which means that they don't have to wait for their priority date to become current. So as a result, most children will be able to get their green cards within 12 months of applying. To determine the processing time of all other categories of children, we must first establish their preference category. Okay, so let's check out the USCIS preference category section. USCIS considers children of US citizens who are unmarried and under 21 immediate relatives. Also note that instead of being called children, they're called sons and daughters. In the same way, if they're married, they fall under the third preference category, or F3. If you're a green card holder and your children are unmarried and under 21, they fall under the second preference A category, or F2A. And if they're over 21, they fall under the second preference B category, or F2B. These categories are very important to determine the processing time. Let's now go to the Department of State's Visa Bulletin for March 2023. This website will tell us when your children can apply for a green card. You can see that the date listed next to F1 or the first preference category is December 1st, 2014. Okay, so say that you filed your application on November 1st, 2014. Because your filing date is the same as your priority date, in this case, your priority date is November 1st, 2014. So your priority date is a month before the date shown on the visa bulletin. This means that your priority date is current and your children can now apply for the green card. The filing fees for your children's green card is $1,760 if they live in the US and $1,200 if they live abroad. These fees are subject to change. Adjustment of status is a process which permits your child to apply for a green card when they're present in the US. If your children live in the US and they are in the immediate relative category, they may apply for the green card at the same time that you file Form I-130. This is called concurrent filing. If your children are in any other category, they'll have to wait for their priority date to become current. If your child lives abroad, the USCIS will review your form and make a decision. Once it approves your Form I-130, it will send your file to the National Visa Center, or NVC. When your priority date is current, the NVC processes your file and sends your children a notice with important case information. Your children can now apply for the green card. The final step in the application process is the green card interview. Your child must attend this interview and hopefully get their green card. If you have any questions, you can contact my office, and if you found this video useful, please like and subscribe.